2nd, 2019. My name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. Members of the public at this time, please take a minute to turn off your cell phones or other devices or silence them so that the board will have an opportunity to hear all of the cases without interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, photographs, and other documents to comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. If there is opposition present, the rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes for that rebuttal. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provision of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because the BZA meetings are recorded for the Metro Nashville network, it is imperative that anyone wishing to address the board please come forward, sit at the table, speak into the microphone, and identify yourself by name and address before making your desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing will be deemed denied by operation of law. Pursuant to board appeal rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of an order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the public hearing. After that time elapses, the board decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding cases that have been deferred. Case 2019-079 involving property at 6503 Premier Drive has been deferred to May 16th. Case 2019-187 has been withdrawn. Case 2019-191 involving property at 901 12th Avenue South has been deferred to May 16th. And case 2019-192 involving property at 545 Westboro Drive and 6300 Thunderbird Drive has been deferred to May 16th. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for the consent agenda, please raise your hand, make sure I see you, and we'll pull it off of the consent agenda and here in its regular order. Mr. Chairman, as we are still waiting for our 4th member, I wanted to get through the preliminary announcements, but for the public's sake, we cannot proceed with the consent agenda until we have our 4th member. So as soon as she gets here, we'll be ready to proceed.
Okay, great, thank you.
So we will take a break briefly until she arrives, and then we'll move forward with the consent agenda.
And just for the information of the folks here, you know, all the boards, all the county boards are volunteer boards. Folks on the board are appointed by the mayor and approved by the council, and they are voluntary boards, meaning that we don't get paid to serve on the board. And this board is a 7-member board, but there are only 6 members that have been appointed to date. I think that we're going to have a 7th member come in May, but what it means is that I've been on this board, I think, 7 years now, and every once in a while, I think this is maybe the first or second time where we really didn't have 4 people here because of people's schedules and travel and other things that they have to do. So I apologize for the wait, and I hope that our 4th board member is able to be here, and if not, then we will adjourn and reconvene on the 16th of May, where these cases would be first on the docket. But again, we're not anticipating that, but should that happen, I just wanted to make sure everybody knew the context of what was happening.
We might take a short break if the remaining members are so inclined until Ms. Sanford arrives.
Sure.
Okay, so the cases that have been recommended for the consent agenda, 2019-174 involving property at 3600 Chalmette Court. I would point out for the board, the applicant has agreed to the condition that the rear patio will not be enclosed, nor will it be cooled or heated with an HVAC. It will only be covered. Case 2000, is there anyone here in opposition to case 174? Seeing none, the next case is 2019-177 involving property at 1716A Nassau Street. This is a sidewalk variance request. The applicant has agreed to the planning's recommendations. Case 2019-1, is there anyone here in opposition to case 177? Next case, 2019-178 involving property at 1612 K Hall Avenue. This is another sidewalk variance request. Applicant has agreed to the planning's recommendations. Is anyone here in opposition to case 178? Next case, 2019-180 involving property at 1001 11th Avenue North. Sidewalk variance request. Applicant has agreed to planning's recommendations. Is there anyone here in opposition to case 180? Next case, 2019-181 involving property at 34 Shepherd Street. This is a sidewalk variance request, and the applicant has agreed to planning's recommendations. Is there anyone here in opposition to case 181? Next case, 2019-183 involving property at 1043rd Avenue North. This is a sidewalk variance request. The applicant has agreed to planning's recommendations. Is there anyone here in opposition to case 183? The last case for the consent agenda is case 2019-189 involving property at 2114 and 2116 Greenwood Avenue. Is there anyone here in opposition to case 189? Seeing none, Mr. Chairman, to review the cases on consent agenda are as follows. Case 2019-174, 2019-177, 2019-178, 2019-180, 2019-181, 2019-183, and 2019-189. Staff would solicit a vote from the board at this time.
We have a motion for the consent agenda. Is there a second? Second. We have a motion and a second. All in favor, say aye. Aye. Any opposed? Motion passes.
Members of the public, if your case was just approved on the consent agenda, you're free to go. Please give our staff until Monday to process all the required documentation and then come into our office in order to obtain those permits. Mr. Chairman, at this point, we usually call on council members. I do not see any here, so unless I'm missing something, I believe we're ready to proceed with the docket. The first item on the agenda is the proposed rule change for the board rules.
Okay, yeah. One of the things that when you all elected me chair. I had my first meeting with Emily and John. We're talking about ways to make our board maybe a little bit more efficient, get us some information a little bit faster. As most of you know, our agendas have become very lengthy. Today is actually a short one. There's only 7 pages of cases, and it's not been unusual to have 13 or more pages of cases, 2 to 3 per page. And so it is thought that it would be helpful to everybody, including the staff, if we required that all documents for cases be submitted no later than noon, no later than the close of business on the Thursday 1 week before the hearing. Currently, people are allowed to present their documents by noon on Monday before the hearing, but that would give us, it would give the staff the opportunity to get the packets to us before the weekend. It would give much longer notice time for the public on the website to review this before they chose to come on Thursday. And it seemed like just a positive rule change overall. So, I think for the public who send letters of opposition or council members who send their opinions one way or the other, I mean, we take those up until the hearing. It won't impact people's ability to express themselves that way. But anyone who's asking for a variance or asking to be on the docket would have to provide their information 1 week in advance. So that is the proposed rule change, and I'll open that up for discussion.
I think that it's a good rule change, and I would support it.
I agree.
Okay, if there's,
I'll move that it be approved.
okay, there's a motion that we approve that.
If I could solicit one clarification, please, at what point do you want this to take effect so that we can make sure the public has adequate notice of the rule change?
I would like for it to take effect the first meeting of June, because I think that everyone on the May docket's pretty well set, but I think the first meeting in June would be.
That would work, and that would also give us time to get the updated rules to the clerk.
And I
Metro
think
clerk.
that, we can be reasonably flexible. I think there are some cases that we've heard in the past that had, 2 or 3 inches of material that they presented to us on Tuesday. And I think that would, to me, after this rule goes into effect, that is certainly would warrant a deferral. But I think, again, if it's a one-pager or something that somebody's submitting late, then we can use our judgment, and if people object to it, then we'll defer it, and if they don't, then we'll move forward. But I'd like for it to take effect the 1st of June.
And I'll amend my motion
okay?
accordingly, that it take effect first.
And I agree with that amendment.
Okay. So we have a motion, we have a second. Is there any more discussion? All in favor of the rule change, say aye.
Aye.
That rule is changed. Let's go to our first case.
The first case for the board to consider is case 2019-131 involving property at 1525 Preston Drive, requesting a variance from the sidewalk requirements in order to construct 2 single-family houses without building sidewalks or paying into the fund. Is the appellant Jacob Bender here? Jacob Bender? Mr. Chairman, it is up to the board at this point whether you want to defer it or if you would.
We haven't deferred this.
Is there any representative from Jackson Valley Land Partners for the case at 1525 Preston Drive?
Well, I mean, it's typical that we would defer this. Planning has recommended disapproval, that they should pay into the fund. But I think, our informal rules would say defer it at least once and allow them to show. And if they don't, then we can take a vote. Does anybody object to that? Then I'll move that we defer this to the next meeting.
Second.
There's a motion, there's a second. All in favor, say aye.
Aye.
Motion passes. Next case.
Next case is 2019-141 involving property at 4243 Eaton's Creek Road, requesting a special exception for a daycare, to open a daycare in a home. The board will likely recall that this was previously heard at the last meeting and it was deferred in order to have a community meeting. I will refresh your memory with the zoning map here showing the zoning is RS15. Aerial photography giving you a sense of the surrounding area. Site plan showing you the property where the daycare would go. And finally, the photos showing you the current conditions of the property. Is there anyone here in opposition to case 141? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please identify yourself by name and address before speaking to the board.
And I believe that, I think we were all here before at the last meeting, so if you could just tell us, I know that part of what we'd ask you to do is go meet with your council member and the neighbors that might have concerns or questions. I don't see any of them here, so I assume that means that you've answered those questions. But if you could tell us what you've done after you give your name and address, just tell us, kind of update us on your proposal.
Brittany Fitzgerald, 4243 Edens Creek Road. I just went back and did the community meeting, and the lady who was here to oppose, she showed up with the concerns that she had, and I'm assuming that she's okay now. But I did address the fencing, I addressed safety, everything that she was concerned about, I addressed.
Okay, and then did your council member have anything else to add? Are there any questions for the applicant? Okay, is there anything else you'd like to add? Because I know you've already gone through the spiel once, and I just want to, I don't want to make you have to go through it again unless you have, like I said, but you have 4 minutes and 30 seconds to say whatever you'd like, but I just want to make sure that you have the opportunity to do that. But we all, again, it was just a couple weeks ago, so I think we all remember your case.
I don't have anything else to say.
Okay. Anybody else?
I would like to ask one question. How many came to your community meeting?
Just 2 people.
Just two.
And just people that was in support of me, but 2 people out of the neighborhood.
Okay, thanks.
Any other questions for the applicant? We'll close the public hearing and discuss. I do know that we have a recommendation from the planning department that we do approve the application, and that from last time, it was noted that a lot of the concerns that people did have are regulated by state agencies that take a much closer look at that than we're expected to do, that they have to get their approval through the state agencies. So does anybody have any comments or concerns or questions?
I was just going to say, it seems like the applicant has done everything and above everything that she needed to do in order to present this, and I'm willing to support it and make a motion to approve planning's recommendation and to approve the special exception. So.
Okay, great. And there's a motion, there's a second. Is there any discussion? Okay, a motion and a second. All in favor of the motion, say aye. Raise your hand. Any opposed? Passes 4-0. Good luck. Thank you. And thanks for your patience and willingness to have the extra meeting and go above and beyond. Appreciate it. Next case.
Case 2019-179 involving property at 4057 Mills Road, requesting a variance from the floor area ratio requirements in order to construct a garage. Is Lee Moreno here? If you'll come forward to the front table, please. For the board, before you now is the zoning map showing you the zoning of the property is R8. Aerial photography giving you a sense of the surrounding area. The site plan is submitted by the applicant. And then finally, the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 179?
And before we start, can you tell us, I have in my notes that the applicant wants to build an 1,800 square foot garage. Do you know what is legally allowed?
So according to the code, the maximum would be 700 square feet or 50% of the dwelling on the property, whichever is greater. According to the tax assessor's website, the structure is 1,336 square feet. So 700 would be the max because 50% of the house is less than 700, and the code allows 700 or 50%, whichever is greater. So the maximum would be 700 square feet.
Great, thank you. All right, if you would state your name and tell us why you're here.
If you'll turn your microphone on, please.
Speaker? Okay. So my name is Leo Moreno, and I live in 4057 Mills Road. And basically, I want to build a 30 by 40 garage. Sorry, it's 30 by 60 on the backside of my property. I'm not sure if you can see the aerial view there, but my neighbor has a garage right next to me. His garage is 35 by 50, and so I want to build something similar to that in around the same location. So I brought a map of the area where I want to build it.
And so tell me, I mean, you had said that you want a garage big enough to put, is it 3 cars or, I mean?
Well, I have.
This is bigger than most houses.
Well, I know, but I got.
I mean, and a 700 square foot garage, our architects are not here, but I think a 700 square foot garage will get 3 cars, so.
Well, I have a boat, I have 3 motorcycles, a car, and a truck. So I know that unless you drive motorcycles, why I have 3 motorcycles. But yeah, I would like to have a big garage to, have all my stuff in there.
And so I guess the one thing that we have to do as a board is we look at a variance, we say, well, what's the hardship? And I know, if I were you and I saw that my neighbor had something, I would say, well, I should be able to have it too. I understand that, but the rules don't allow us to do that. We're supposed to have a hardship. And so
Okay.
that's what I'm trying to figure out is what, again, and you unless you are here a lot, you don't know what our rules are and that kind of thing. So I don't expect you to know that. But again, an 1,800 square foot garage on a property that has a 1,300 square foot house with a 700 square foot limit says there
Yes.
needs to be something kind of exceptional about this.
Well, I mean,
To
I own
allow
the
that.
property right next to it, and between the 2 properties, there's 1.3 of an acre. So, I mean, I have enough land. I mean, I got apartment buildings on one side, apartment buildings on the other side, and this is a stretch of land that has only 4 houses, which every house has at least 2 acres. And, I mean, that was the reason why I wanted a place where I could have some land and have a garage big enough so I could put my stuff in it.
And so you said you own the property,
Right
do you
next
own
to
the
it.
property that touches Bell Road?
Yes, right next to Bell. There's
So-
2 lots. The one at the very corner, that's 0.6 of an acre. Someone else owns it. But in between my house and that other corner,
Okay, so there's one lot that's on Bell Road and Mills Road, and then you you own the 2 lots next to it that include your house?
yes.
Okay.
And so if you could see right now, there was a small garage there in the backside. So that was only like 17 by 12, and I wasn't able to put in my boat inside.
And okay. And what type of garage are you planning to build?
Well, it's going to be a gable roof. Probably it's going to be about 10 feet high. And so the size is going to be pretty much the size of my house. The outside is going to be like hardy board siding. And I'm going to paint it the same color as my house.
Okay. All right, is there any questions for the applicant?
I'd like to know if any of the neighbors object and what his council member, I don't even know who his council member is. It's District 14. And if he had talked with a council member.
Yeah, have you heard from any of your neighbors or?
I actually talked to all of them once I got the letters. So I only had 2 letters for each apartment building and 1 letter for 3 neighbors in that street. So, I mean, I went and talked to them, to every single, all of the neighbors, and show them what I wanted to do. So they were okay with it. So, I mean, I don't know if you can have another view of that area, but everybody behind their houses, they have a lot of stuff in it, even laying around on the outside. So I'm thinking, instead of having things laying around outside, I would rather have a garage and keep it all.
From the photo, your neighbor has a lot of cars in the back too that are not in that garage, right? you're
So,
saying-
I mean, that's a way of keeping the area clean.
So what's the smallest garage that you could have to meet your needs?
I really want,
I know what you
30 by
want,
60.
because that's what you asked for, but tell me, if you don't, and the code doesn't allow that, which is why you're here, and I don't even know, like I said, there are only 4 of us, and so we all have to agree if you're, and you may not have, there may be some of my, I tell you, I don't know how I feel about it. I'm just trying to talk it through so that when we discuss it, we can have full information.
okay?
Because right now, I don't see the hardship, but I don't see the harm. And sometimes that what makes you unique and thus a hardship is where you are and what your neighbors are like and how that might be different than the base code that you're on.
Well,
But I'm just saying, if it's a stretch for folks, what is the minimum that you would need to?
I mean, I would think 50 by 30, even though I'm not,
Why does
I mean, all my
why does
neighbors-
it need to be 30 feet deep?
oh, because
I
I
mean,
want
most
to be able
garages
to,
are 20.
well, because I want to be able to park the garage and have some, either some kind of tools or
Right.
anything that, to work on my motorcycles or my car.
Okay. All right. Is there anything else that you have to tell us to help us understand what you're trying to do?
Well, that's basically is either building that and allowing me to have an enclosed garage where I could put all my stuff, or I mean, I probably have to park it outside, or may install a canopy, which I think it would not look good for that. I would rather have it all inside of a garage.
Okay. Anything else? Any other questions? All right. We will close the public hearing and discuss.
Okay.
Thoughts?
Well, I'm happy that no one is complaining about this, but I agree with you. I don't know what the hardship is here to grant a variance.
Yeah, the only thing I can think that, I mean, on its surface, I think that is absolutely true. I don't see the hardship, and if I were to try to construct one, again, not to necessarily make the case, but to say, is there a path here, is that when you have, such a big piece of land with, not as large a home, if you have a couple acres, then you think it does feel a little more rural, although the overhead picture here doesn't look rural at all with all of the apartment buildings. But you have the land to support, and it's so far enough back that visually it's not a problem, and there's enough tree coverage that it shouldn't be an issue for the neighbors. And it's certainly not as as a person who would live on 2 acres, I would think it would be a lot worse to have all those apartment buildings around me than it would be to have my neighbor with one big garage. But so I guess that's where I see the no harm. But now whether or not it's a request that we can find a hardship that we could all agree to, or whether or not it's a 700 square foot garage that we allow a certain number of square feet as a covered patio attached to it, so that the enclosed structure is not more than code allows. I mean, that might be a path, but others may just see that there's no hardship, and we don't have a vote to allow anything. So
Well, I'm impressed that he did say he talked to his neighbors after they got the letter, and that he didn't run into any opposition, and obviously no one's here today. And I don't know of any letters. I don't see any in our packet that came against it.
I think you make a really good point, which is there is no harm, but there is no hardship either, and that I see, and I don't see any hardship at all, and if I don't see any hardship at all, I couldn't vote for it.
Well, I don't think that we're going to get a motion that passes today, but I'll throw one out there to see if it gets any votes, and if it does, then it can maybe be held open for others to consider, and if or not. But I'll move that we approve a variance for a garage on this property that has no more than 700 square feet enclosed space, but would allow a footprint up to 1,250 square feet of additional covered space of garage, based on the fact that the applicant has an extraordinarily large lot that has tree canopies that shield him from his neighbor, and he owns the lot next door, making his property even larger, and that this building is not disproportionate to the lot.
So there would be, you say 700?
700, he could have a 700 square foot enclosed garage as code allows, but we would allow an additional 550 square feet of covered patio, just unenclosed garage, so that he could park his vehicles under a surface, but it wouldn't be enclosed.
Is that
If it's allowed without us, and I guess to me, the reason I was asking is that if it's allowed to have an additional, a carport, an attached carport to an accessory structure, then he doesn't need a variance, because we probably won't grant his variance, but he could build what I'm describing anyway. And if he can build that, I wouldn't want to limit what he could do by right, but
While the lawyers look to see whether or not that's allowed, I was going to say that I was inclined to agree with you that because I don't see a hardship, it's hard, I'm not inclined to vote for it. But if there's a way to give the 700 square foot garage and the carport is allowed, I'd be inclined to support that motion.
while they're looking that up, I will open the public hearing and allow you, if you have a comment, since.
Well, I was wondering if I could bring a couple of my neighbors. So for support, they actually asked me if they needed, if I wanted them to come, and I said, oh, I don't think it'll be necessary because of, I didn't even think that it was going to be a problem or.
Yeah. Well, I appreciate it. I don't know that it would help, because I think you testified that all your neighbors are in support. We got no letters of opposition, and I think every aspect of our conversation is with the assumption that your neighbors are supportive. It really is, and again, none of the decisions we make are personal. They just are, we have a citizen coming and saying, hey, this is what I want to do. Somebody, you live in the county, a property in the county, you want to change your land in a certain way, and we're like, okay, if you were your next door neighbor asking the same thing, we're looking at it as a property, and the rules that we have to be able to allow you to do this, we're trying to figure out something that we can all live with. And again, 4 of us have to vote for you, and there are only 4 of us here, so we all have to vote for a motion for it to pass. And if we don't, then it just carries on into the next hearing until we get enough people that can vote one way or the other, either for something or not. Have y'all found out anything?
And Mr. Chairman, I will say, not having been prepared for that particular question and not having a chance to look into it further, I will say I do think that motion or idea is something that y'all can do. With respect to whether or not it's allowed by right, passing that motion would not limit that right. Obviously, it's just an order giving him permission to do what he's allowed to do. So it doesn't really hurt to go ahead and move forward on that.
Okay, so that would be my motion, and knowing that that's a minimum right that we're establishing, and that if codes allows him to do something more differently, then he would be allowed to do that. But my motion is to allow him to at least build a 700 square foot enclosed garage with an additional 550 square foot carport.
And I would second that.
All right, so that motion, and that carport not be allowed to be enclosed was the implication of that.
in the discussion, so we don't know whether the additional 500-foot uncovered would be code compliant?
I don't know right now. That's something I'd have to look at further.
Is there any further discussion or?
So
Well, it's larger than the surrounding lots. The others are, I mean, on the visual we see, everything around it is dense multifamily, except for the two other homes that are just, I don't know if it's north or, I don't know the direction, but to the top of the picture. And, you know, his neighbor has a really super large, a much larger garage than, you know, we would be allowing him to build. And so that, it doesn't seem inappropriate to the single-family homes that are there, and the single-family homes that are there have much larger lots, space per people, say, per person, than the multifamily around him. And again, given the trees and everything else, it seems like it is a reasonable accommodation for him without any harm to his neighbor.
Well,
Okay. Well, I kind of took the shotgun approach to hardships, hoping one of the pellets would resonate with at least one each of you, you know, trying to give it, you know, and again, it was just, is there an angle of it that resonates, and however, and I think that, again, it's not a precedent. Every lot is different, every case is different, and I don't know that we've ever seen a lot like this surrounded by apartments that was that large and treed, and this is an unusual lot that we've seen for this type of request. So, is there any other discussion on the motion? We have a motion, we have a second, and all those in favor of the motion say aye and raise your hand. Any opposed? The motion passes 4-0. Then you're allowed to build a 700 square foot garage with a 550 square foot patio. Codes may allow you to build a larger patio, but they have not, that was not a question that was anticipated, and you'll have to talk to codes about that, but you're at least allowed 700 enclosed and some additional patio space. So, wish you luck.
Is there a way that I'm able to appeal, or if I talk to my council member and see if...
If you have a substantially different, and you can talk to the codes folks after, but if you have a substantially different proposal, you can appeal again to us. If your council member wants to weigh in, and that may be considered new information, then someone might want to raise it. If you go back and listen to the tape, which you can on the internet, I think that you will hear that it will be a tough sell with our board in terms of the way we look at hardship. I think you got a pretty generous result based on the opinions of the group. But absolutely, the council, I mean, the code staff can tell you exactly what to do to change your plan and bring it back as a different plan.
Okay.
All right.
Okay. Thank you.
Sure thing. Good luck. Next case.
Case 2019-182 involving property at 16 Claiborne Street, requesting a variance from sidewalk requirements in order to construct 2 single-family houses without building sidewalks or paying into the fund. Before you is the zoning map showing you the zoning of the property is R6, aerial photography giving you a sense of the surrounding area, proposed site plan for this project, and finally, photographs showing you the current conditions of the property as well as an up and down the street. Is there anyone here in opposition to case 182? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please identify yourself by name and address before speaking to the board.
Josh Helmer, 1071 2nd Avenue South.
Michael Elliott, Michael Elliott, home address?
Home address, yeah.
3844 South Mount Juliet Road, Hermitage.
All right, so the planning department asks that you expand the sidewalks along Perkins to reduce utility obstructions and ensure ADA compliance, and to maintain the existing conditions along Claiborne in good repair, and if it's not ADA compliant, to remove that and replace with in-kind or ADA compliant materials. So what was wrong with planning's recommendation?
So we reached out to Councilman Sledge after we received the last variance to build the two houses and kind of went over what we were going to do. The Claiborne sidewalks, I think, are in compliance right now, but if they weren't, we're willing to bring those in compliance. The Perkins Street is difficult because there's an existing curb cut there right now that's going to go away, and we're going to put a new one in. And there's also going to be 2 new water lines and 2 new gas lines. So we're basically going to replace that entire sidewalk with what's there, just brand new. We can't expand due to a variance that we were granted months ago. We got an 8-foot side setback variance, and I believe they're looking for 9 feet of sidewalk, 4 feet of grass strip, 5 feet of sidewalk.
Where do you see that? Because what I see on there, what I see is the applicant shall coordinate with Public Works to expand the sidewalks along Perkins and reduce utility obstructions. So to me, what I read is you need to work with Public Works to expand the sidewalk, but it doesn't say anything about a 4-foot grass strip and a 5-foot sidewalk. So I mean, tell me what you all are hearing from folks that led to confusion and y'all sitting here.
And Mr. Chairman, while the appellants are trying to pull up a little information, I would note at the beginning or at the top of those planning recommendations, it spells out what the code requirements are. Here it does specify the 5 and 4 specifically identified for both of those streets. So that may be a point of confusion. That's what the code requires. Then, of course, at the bottom of the planning recommendations where they talk about the more workable solution that they think they've identified for this.
Yeah, thank you. That may be where the confusion is, and it may be that we need to could go back to Public Works. So
yeah, so maybe that is the confusion. Maybe we just need to know exactly what they're looking for. We just know that the code compliant 4 feet of grass strip, 5-foot sidewalks won't work because it'll put 1 foot of the sidewalk in the house.
all right, too neighborly, right?
It'd be too neighborly, exactly.
Well,
so whatever needs to be done in Claiborne, we're happy to do. Perkins is just a very low traffic area, and with the side setback variance, we weren't sure what they were looking for.
From what, again, everybody may read that recommendations differently, but when I read the recommendations, when it says work with Public Works to widen the sidewalk along Perkins, that to me says leave it where it is but widen it. It mentions no grass strip or anything. So does it make sense to defer this so that you all can talk with Public Works and planning so we know exactly what it is? Because if you agree with Public Works, you've already agreed with the second condition, which was maintain Claiborne and repair it as needed. And the first condition is if we understand exactly what they want on Perkins, then it would be on the consent agenda if you agree with the planning recommendation. So
yeah.
Does that make sense because I don't know that I have enough information to give you a variance, because what I read sounds reasonable, but what your interpretation is, this isn't reasonable because this is how we think they want it to be, and I think we need clarity on what they really want.
Yeah, because if they're just saying add 2 additional feet of sidewalk, that's easy.
Yeah, and that's what I read is widen the sidewalk on Perkins, and as you said, that's easy. And so do you object to deferring this to the next meeting? And then if you clear that up, it'll, like I said, if you as is per our rule, if you agree to planning's recommendation on sidewalks, we put that on the consent agenda.
Yeah.
Okay.
We're fine with that.
Then I'll move that we defer that to the next meeting.
Second.
Deferral, we have a motion, a second. All in favor, say aye. So we will see you in 2 weeks.
Thank you.
Case 2019-193 involving property at 114B Taggart Avenue, requesting a variance from height requirements to construct a garage. Before you is the zoning map showing you the zoning of the property is RS20. Aerial photography giving you a sense of the surrounding area. Site plan is submitted by the applicant. And then finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 193? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please do identify yourself by name and address before making that presentation.
Good afternoon. My name is Matt Smith. I work for Howard & Smith Contractors, 7065 Moores Lane. I'm here for the Sloan family. We're building that home at 114 Taggart. We are requesting a variance or interpretation. The current garage as drawn, I guess it's not current, but the garage as drawn tops out at the very tip of the roof at about 21 feet. I believe the exact code asks for 16 feet. Just a couple of details may not matter. The vertical walls only go up to 10.5. The second story actually only goes up to about 18 feet. So that additional 3 is really just roof pitch, trying to get to the tip there. In speaking with the architect, his belief was that the breezeway connecting, there's an unbroken connection between the home and the garage, would make that one structure. I was informed by codes that, I'm not sure if that has stopped or was never the case, but that is not the case, and was kind of recommended to BZA.
You said an additional 3 feet, or did you mean 5? Because you want to build at 21 feet and code is 16, is that correct?
Correct. The 3 feet, I guess I was referring to, I'm not sure if y'all have the plans, I have a copy here. The actual second story, I guess, tops out at 18 feet. The last 3 feet is
What does not comply with code? Is that what you're saying?
Well,
There's
I guess there are 5 feet that don't comply with code, sir.
Pardon me?
The 5 feet
Does not.
is a variance, yes, sir. This was done, bringing that garage into the home would probably raise the height, would look over directly into a neighbor's, I believe, bedroom, but into their backyard and home. We thought this was the least injurious way to proceed. I have 6 letters of support from neighbors that received the mailing, including both directly adjacent neighbors. Also, just doing some minor research, again, I'm not sure if this matters, on Taggart Avenue and the street directly parallel with Taggart, there are only about 30 homes. There are 3 completely detached garages that are well over 20 feet. I've got pictures and addresses of those, if that matters. One of them in 2013 received a BZA variance for height. I'm not sure exactly what they're rejected on setback, but received a 28.5-foot height variance.
Is that the modern house?
I'm sorry.
Was that variance, do you know, what does that garage look like that had the 28-foot variance? Is it I think there was I kind of started to remember a real modern looking garage that was approved, and I don't.
To be honest, it's one of those two. Those are the 2 on Brookfield, and this is the one on Taggart. So, well above what we're asking for, and clearly 2 stories and above the height.
Okay. Do you have,
And then
do you have other copies? Can you just share with everybody?
Yes. Sorry.
So what is the,
Copies, the pictures of the last 3.
These are neighbors. These are just neighbor.
And these are neighbor
garages that are taller than what they want to do.
And here is our clear split.
Great, thank you.
so what is the hardship that requires the variance?
The hardship was our attempt to replicate the master plan or the site plan that was there before, that fits in best with the neighborhood and was least detrimental to the neighbors in terms of having something that really loomed over them.
And so I guess, to me, when I was reading the application, I thought that the code said you're limited to 16 feet, let's see, or 1 story, but you.
I believe it reads 16 feet or 1 story, whichever is less. We do.
But how is 1 story, I guess to me, 1 story is always going to be less. I mean, I don't understand how you get a 2-story structure with that sentence. Am I reading that wrong? Maximum height of 1 story or 16 feet, whichever is less.
Well, I
mean,
assumed that
if you had
meant
an
you could have a
18
two-story, I guess, under that 16-foot. Was my reading of such. And I say that just in looking at the urban zone overlay and the bigger lot rules all have similar language, allowing a little bigger, but I think it's clear on those they mean 2 stories would work as well.
Okay.
So
And,
I kind of.
Now, I know you have a lot of neighbor support, and I appreciate it. It makes them, that's nice and helpful. They said the president of the board of Belmead Highlands Neighborhood Association. I don't know if, is that your neighborhood, the association of this neighborhood, this home?
Yes. Hello, I'm Benson Sloan, the homeowner of 114 Taggart. Angie Henderson is the chairwoman of the board.
Right. Well, and she's the Metro Council member who sent us an email saying that she's not able to be here. She's been a member of and president of the Belmead Heights Neighborhood Association, where the home is located, and it basically says make sure there's a hardship. And she said regarding the request for height variance for the garage, the president of the Belmead Highlands Neighborhood Association, copied here, conveyed the following yesterday evening. The board discussed and agrees with continued opposition to variances without hardship. We defer to the BZA and their determination of whether a hardship exists in this case. So I guess they're looking for us to come up with the hardship. And it seems like that they're being polite and hedging their opposition.
Yep, so I spoke with Angie Henderson this morning regarding this case, and she was not directly opposed to what we are planning here. It was more that she didn't want to make a judgment on this specific plan, so it didn't set a precedent for her having to judge other plans in the future. I think that's consistent with what she's done in the past. So, yeah, that's her position.
And so what would be the closest you could get to 16 feet? I mean, you said that the second floor tops out at 18 feet, and you have to have that. That means, it sounds to me like you got 3 feet of roof in there that you don't have to have if you put a different type of roof on there. And 2-foot variance seems a little more stomachable than a 5-foot variance. I don't know the other folks here, but it does to me. So why do you have to have that exact roof, and can you not achieve what you want to do with a lower roof?
So if I can speak to a couple points here. We originally proposed having a detached garage to but sort of fall in line with what you can see is consistent in the neighborhood, where there are multiple homes with detached garages. With our architect, we believe that having that detached garage with a room above it was aesthetically pleasing for us as well as the neighborhood. By moving that garage into the actual main home would mean that the garage would have a full second story above it that would be the full size of the house. So I think that's around 31 feet. And to Matt's point, you can see if that comes into the home, it would be looming over our neighbor, which would be less aesthetically pleasing. So having it detached, we think is additive to the neighborhood as opposed to a detriment. Again, the second floor only tops out at 18 feet, and so part of that, what's breaching the variance, is 3 feet of roof pitch, which I don't know if my opinion matters, but it doesn't, to me, that doesn't equate to having a full second floor that's 21 feet with additional roof on top of that.
But I guess, I appreciate all that, and then you probably explained very nicely why your neighbors signed off on agreeing to your plan, because it is probably a better plan for the neighbors, which doesn't necessarily help us with hardship and that type of thing. But again, and I'm not an architect, and I didn't ask your profession, but you said you hired an architect, so I assume that you're not an architect.
Correct.
So we may not know the answer, but the question was, why can't, why does it have to have such a steep pitched roof instead of a roof that has, a flat roof on top or something else that would cause you not to be as high?
Yeah, and I think it's just proportional to the main house as well as proportional to the style of the main house as well as proportional to the garage. And so if you cut that roof pitch off, I think the neighbors wouldn't prefer that as opposed to keeping it with something that looks nice.
Okay. Any questions?
I want to ask a question. I want to make sure I understand. You're saying that you've chosen not to have it attached to your home. Does the lot, and I don't have a picture of it, so my screen here doesn't work. But are you saying that you've chosen to have that because of the neighbors? I happen to live in a house with an attached garage, and I find it wonderful because then I can go in it and close the door and feel safer. But are you saying that if you attached it to your home, that you could actually have it taller and not be in or out of compliance with codes?
Sure.
Did I understand that correctly?
So we looked at several options. One, our interpretation was that having it connected by a breezeway was interpreting it to be a single dwelling as opposed to two. We were incorrect in that assumption. So we looked at options, and if we connected it to the house, we would be taking up more land, so reducing the backyard, the grass area, and potentially having to tear down another old tree. And so we have tried to figure out the most appropriate way to achieve having the most green space while keeping as many trees as possible.
How many trees do you think that you would lose if you did attach the garage to the house? And you said you would lose another old tree. Tell me about that tree. How big is it? What kind is it? And how tall?
So if we brought it in, we would reconsider the configuration of the home and have to redo the plans. And it's likely that it would come in and possibly move to the other side. And so there is I don't know how tall that tree is, maybe 40 feet, which has been there
Longer than we've...
Longer than I'm alive. Yeah.
Probably me too. That's even more than that. Okay.
So, Ms. Sanford, to answer your question, that was our approach.
So perhaps avoiding moving that tree might be your hardship?
It's I don't know the regulations, but that's possible.
Any other questions, or is there anything else that you all have to add, would like to add?
No, sir.
Okay. Okay, we'll close the public hearing. Thoughts? This board has in the past, and again, we have a new board, and so the board may not now or in the future view this way, but in the past, the board has considered mature trees and the loss of mature trees as a potential hardship, depending upon what was planned and that type of thing. I think that would be the angle if you were to believe this to be a hardship situation, that would be one to consider. And it also is, there's a little bit of kind of the lesser of two evils on it, on this type of case, because we've had cases, I think that I can remember, where we had a height variance on a garage, and I think it was in Woodbine, where the case was made, I can attach this to my home and it'll be a full 2-story structure that will swallow up in this case, their modest home, and they wanted an extra 3 or 4 feet in the back to kind of do what these folks are doing, and they had some topographical issues and some tree issues that we were able to articulate into a hardship, but it also was one of those things that made sense. And so I guess this is, to me, a question of, does this make sense enough in terms of what they can do and probably will do if they don't get the variance?
Well, I think we need to connect the not having to move the tree with the fact that it appears that the plan that he's proposing would be more aesthetically pleasing to his neighbors, and that they're not here opposing him. And Councilwoman Henderson is not here opposing him. I appreciated her letter, and I have the highest regard for her as a council member. But I think if we combine that, not taking down the tree, with the fact that it appears that it would be more aesthetically pleasing to the neighbors, that would be enough for us to allow the variance.
So, question, I'm trying to make my mind up on this, because I'm uncomfortable with it's almost a third, the zoning requirement is, it's almost a third higher than the zoning requirement. How is it a hardship? They could still build a garage, but just build it 5 feet less in height. I think saying, well, you know, if we don't build it and get the extra 5 feet, then we're going to have to build it and take down a tree. There's another alternative to me, which is build a garage, but build it 5 feet less. And I'd still want to see a hardship if it were even 17 feet, because I don't think we want to get into a habit of people thinking, well, if I'm a foot over, that'll be okay. But, you know, it's 5 feet over, and I see that the hardship of taking down the tree is eliminated by changing the plans and making it 5 feet less in height.
Well, the one piece that I got an answer, but I think it was, to me, that it fell into the choice, personal choice, versus what can I do is, you know, why 21 instead of 19, you know, break up the roof pitch and have a smaller roof pitch on the second floor, and, you know, you top out at 19, and, you know, because 18 on the inside, you know, again, I'm not an architect or engineer, but it just seemed like there should be a more creative solution for what is the minimum height you need in order to have your second story, which is, I think, arguably a modest second story compared to most likely what you would put over an attached garage. And I think that's where the neighbors came in, and I tend to agree with Alma that, you know, I think that, you know, almost any time you build something, it's a choice. And, you know, I think they've chosen that they need that square footage for whatever reason, and
I understand that.
yeah, so I mean, that's what I don't know. I mean, you know, like I said, the 21 versus maybe something lower is where I stick a little bit, but whether they should do it or not, you know, I don't have as much of a problem because the neighbors are supporting it as being a preferable solution to them. You know, I mean, you're getting kind of the same end goal of what you want, but it's not out of place for what the neighbors are doing and the actual people impacted. And in fact, the one right next to him, it looks like has the exact same kind of garage. And so they're like, well, I'd rather you having the garage out in the back like we do than right next door looking in my window. You know, I get that. I mean, and the houses clearly in this neighborhood have been, look like they're relatively new, and they sure are maximizing the space on the lot. So your windows aren't too far from each other in this neighborhood. But again, in terms of the hardship, it's tough. I mean, I think that the tree, I don't know, what do you have?
I'm also struggling with this because I'm trying to find the hardship. I understand the aesthetics argument, and I understand that the neighbor is most affected by it, but I don't see the hardship. I want to know what's unique about this property that prevents a different way to build this that doesn't impact the mature tree. I mean, this is in a RS 20 zone, so these lots look pretty large and deep. So I guess, can the height of the garage, if you want it detached, why can't it be lower? Like, what's the reason? So I think that's where I am too.
May I make a comment?
Does anybody object to we'll reopen the public hearing? Sure.
So to address a couple of your thoughts around, well, why not just reduce the second floor of the garage? So we are trying to have that as livable space. There are several reasons for why we would like to have that space over the garage. If we were not able to build the garage to the height requirements that we're seeking, we would have to reconsider our plans and bring that garage into the home to have that space, to add that space, livable space for what we would like to have. And by moving that garage into the home, it looks like we will have to tear down another tree, the mature tree.
Will you not have any livable space if you build this garage? Isn't there a way to still have livable space above the garage, but to reduce the height by 5 feet? Is that not possible? You might have less, I understand that. It might not be as high as ceilings, but it is.
I don't think so, because the slab of the garage to the ceiling is about 9 feet. Then you've got a foot or so of flooring, and then to stay under the requirements, your second floor would be, I don't know the math, maybe 5 feet.
You'd have about a 5.5 foot ceiling.
So I'm 6'1", so I couldn't walk in there.
Is there a way to lower the height of the garage level to get more space out of the top, or are you maxed out on that?
It's about as low as it can go. With an 8-foot garage door and a room for a garage door opener, you can't really get lower than we are.
Any other questions? All right, we will reclose the public hearing. See if there's somewhere we can get to other than the next case.
Well, I think what is the hardship is they want to have some living space above the garage. And if that doesn't work, then they've got to consider moving putting the structure connected to the house where they can have the living space. I'm just still not comfortable with that being a hardship, but I mean.
Well, that's fair enough. I mean, that's why, as we say, there's 7 of us on the board. Everybody brings a little different perspective to it, and that's fair. I mean, and I do think it probably is a perspective, that either resonates or doesn't, and because it, and how you, as a board member, I have to feel like, well, am I comfortable in how I look at something, and everybody has a different measure of what they're comfortable with, so I fully respect that, but, like I said, my hang up on it is really more the height than it is the concept. And, I think, 19 or 20 feet, something that, 19 is something you figure, well, you can, be creative and figure out something, but I'm comfortable with that, but it doesn't sound like there's 4 of us that are comfortable with it, which is okay too. But we probably. Well, I don't know that we're going to get to an answer today. But I will move that we approve a variance of I'm going to say a variance of 20 feet to just give a little bit of flexibility, but I do think that there needs to be something besides the steep pitched roof that comes to a point. And that's a 16% variance. I'll move that we provide a 20-foot variance, well, sorry, 25% variance, since I added that extra foot, sorry about that, based on the hardship of the loss of tree in accommodating a second story above the garage space that would have to be attached without the variance.
I will second it.
So your motion is they would be permitted to go to 20 feet?
To 20 feet.
Okay.
And I'm anticipating that you're not there, but if you're there at 19 or 18 or something, I'd be willing to consider that, to give them some flexibility to be creative. But I'm not anticipating that, so I just said 20.
Sure.
So
You anticipate?
I'm just saying I'll be flexible if there's movement, but fully respect your opinion and views if there's not. So I think there's a motion and a second. Any discussion? Okay, all in favor say aye. Raise your hand. Those that say no, raise your hand and say aye. So the motion fails 2-0. At this point, a motion to deny the variance would probably also fail 2-0. And if someone wants to make it, we can have it out there. Otherwise, this case will be open for 60 days? 30 days.
30 days, but it'll be on the next agenda for May 16th.
So it'll be on the May 16th agenda, and we may have 2 more board members that can hear this again. Hopefully they will watch the tape, and we'll have a chance to vote one way or the other. All right, good luck.
Question, so for the next meeting, would it be helpful and productive to bring back a new plan that shows a potential option of, you propose 20 feet?
If you have new information next time, I think that would be, you absolutely could bring that. That would be up to us to open the public hearing because the other two haven't heard it. Most likely we would, I would say we would allow that. Because I think that's just fair. But you've heard the comments, you've heard the need for a very articulated hardship, and so, like I said, go back and watch the tape, and feel free to come back and make your best case, and we'll see what we can do.
Thank you very much.
Next case is 2019-195 involving property at 808 28th Avenue North, requesting variances from sidewalk and rear setback requirements in order to construct a single-family home. Before you is the zoning map demonstrating the zoning of the property is RS5. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant showing the proposed site for the project for the site. And finally, the photograph showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 195? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please identify yourself by name and address before making that presentation. If you would turn your microphone on, please, sir.
Jeremy Payton, 310 Hazelwood Drive, Brentwood, Tennessee.
Or setback, what is the setback requirement?
20 feet?
20 feet?
Yes, sir.
And you're wanting to go 8 feet on that?
Yes, sir.
Okay.
And is it just 8 feet on the 2 units that have that unimproved alley?
Yes, sir.
And then, so the hardship is to keep these units aligned. There's, however wide that alley is behind the one of the properties that's, now, is anybody using that alley now, or is it?
No, sir. It's completely unimproved.
And
it's
has
a
it
dead
been-
end alley.
So is there the potential to absorb that alley? You know, I think, don't you, if you absorb the alley, you kind of split the difference between the, is that how that works?
Conceptually.
Okay. And then I know that the sidewalk variance, I believe that you all had agreed with planning's recommendation on the sidewalk variance, is that correct?
Yes, sir.
Which was a 4-foot grass strip and a 6-foot sidewalk.
So that's taken care of?
Well, I think we have to vote on it, but they've agreed to planning. So we could
They've
approve
agreed
the
to the
sidewalk variance
recommendation. Okay.
per planning's recommendation if we so choose. But the reason that you weren't on the consent agenda is because of the rear setback that the board needed to hear. I mean, since you agreed, the sidewalk part would have been on consent because you agreed to planning's recommendation. Does everybody understand the alley issue? Okay.
I don't think that I do. So you're wanting to,
Emily, will you put up the,
you're wanting to go into 12 feet?
there it is.
Okay.
There's an alley here that just goes to there. And because of this unimproved alley, for these to kind of line up equally, this other property line, I think, goes back there.
So this is the unimproved alley. So the alley behind these proposed structures is wider than the adjoining alley. Is that what's happening here?
Sir, it's not really an alley. It's just backyard. It's completely non-improved. There is no way to drive back there.
It's just grass?
It's just grass.
Is it?
I think it's zoned as an alley, and the city probably either owns it or the right of way or whoever owns the property I guess the city, but they just have never built an alley on it.
Correct.
And how far is your property to the alley, the unimproved alley, or your building to the unimproved alley?
We're asking for an 8-foot setback, rear
So you're
setback.
12 feet from the,
Yes.
okay. So you're 12 feet from the unimproved alley, but then that unimproved alley goes, there's more than 20 feet between your building and the next property line because you've got
Yes,
the
sir.
unimproved alley.
Yes, sir.
So did the neighboring properties, they must have also obtained a variance? Because they're
We obtained a variance
for those already?
previously.
Previously, okay. And so those are, okay. Those are 8 feet, right? Correct?
Correct.
And you obtained a variance for that. When did you obtain that? Do you recall?
December.
Last year?
December.
I'm Kurt Denny, 1577 Woodmont Boulevard. I'm the owner of the property. In December of 2017, we came to you guys with the variance for the 3 adjoining properties, the sidewalk variances, and then 806, which is the property directly next door. We also came to you for a variance on the rear setback, which you granted.
And what year was that? Did you say December of 2018?
2018.
Yeah, it's 4 months ago. 5 months ago, whenever it is.
I was here, I don't remember it.
I was just thinking the same thing. Did we vote on that?
I'm trying to figure. So you owned all these properties essentially and still own them?
I do.
You own the other 2, and have you developed those and sold those?
No, we have not developed yet.
Okay.
Our original plan was to develop the 3, and we were able to acquire 808. And so before we began, we came back to you guys to essentially get to where we could build 808 the same way that 806. So all the houses would be consistent and
So the two on the right are what you have variances for already, is that correct? Or is it-
Sidewalk only.
correct, yeah.
The two on the right up there, that's what you have variances to have the 8-foot setback.
No, sir.
The 2 on the right didn't need a rear setback
Because that alley
variance
ends, right?
because the alley dead ends.
The alley ends right there.
Oh, I got you, okay.
So we didn't need a rear setback on those.
Okay, that's what I was trying to determine. What was your hardship to get the variance the first time, but you didn't have one because the alley just ends right there? Okay.
We didn't need it.
It doesn't look like it from this diagram because it says utility easement even in the back of those properties. Do you see?
Yes.
See
Yes,
that?
sir.
But you're saying that utility easement is, why is that written? Why does it say utility easement right there where it appears to be? You appear to be within 8 feet of that utility easement. I see the line where the alley's, where it ends right there, but then over to the right is written utility easement. That's what's.
So there is an easement on the back of 802 and 804. It's basically a continuation of that alley, but just for utility only. It's not for right-of-way.
Gotcha, okay. I follow you now. The right-of-way stops, but the utility easement continues.
Correct. It's
So
a
you-
dead-end alley, essentially.
So you did not have to get a setback variance for the utility easement? Okay.
No,
That-
sir.
That was permitted?
Yes, sir.
Correct.
Gotcha, all right.
Any other questions?
Do you have anything else to add?
No, we
No, sir.
All right, we'll close the public hearing and ask for thoughts.
So I have an unimproved alley behind me, and I've always been under the impression that Metro can come back and take their alley whenever they want. And so I try not to build. When my mother built her home, which is on the same block, she didn't go into the alley because she was concerned about that. In this case, one thing I will say, with the way that we're building density, and this project looks great, I am sensitive to having alleys as a separate way of access to properties, and I think it's important, even if the alley's unimproved, to sort of preserve those. But in this case, I guess what I'm saying is, from a precedence perspective, I do want to be careful and note that this is unique because this alley doesn't go anywhere, and it dead ends and it goes. They already have like half of this already kind of built in there, and I think that's an important distinction, because if this unimproved alley went all the way through, then I might look at this differently. So.
Yeah, I agree. I would too. I think that's really fair. And even if they were to reclaim the alley, there's still 12 feet, between them. So I think that to me, that's acceptable too. So I'm agreeing with you.
I agree too.
Is that a motion?
Yes, I guess it is a motion to approve the variance from the rear setback requirements. And it seems like you guys have, to adopt planning's recommendation regarding the sidewalk variance. So that would be my motion.
Okay, we have a motion. Is there a
I'd second it.
We have a motion. We have a second. Any more discussion? Okay, all in favor, say aye.
Aye.
Any opposed? That motion passes. Good luck.
thank you.
Thank you very much.
Moving on now to the short-term rental cases on the docket. First short-term rental case is 2019-171 involving property at 803 Hillview Heights, Units 107 and 108. This is an item A appeal challenging the denial of a short-term rental permit due to operation after the permit had expired. Mr. McBroom is here to make the presentation on behalf of staff. Is there anyone here in opposition to case 171? Seeing none, Mr. McBroom will make his presentation. After he makes his presentation, the appellant will have 5 minutes to make his presentation or hers. Please identify yourself by name and address before making your presentation.
Good afternoon, Board. These two properties are considered together. The information is all the same. On 7/14/16, Type 3 permits were issued. On 6/9/17, permits were renewed. On 7/15/18, the permits expired. August 2018 through April 2019, there were 44 documented stays after the permits had expired. March the 9th, 2019, BZA appeal was filed. March of 2019, there were 7 documented stays, and in April of 2019, there were 3. The website listings have recently been removed, and host tracking does not list the date for that removal. Apparently, the list most recently read a minimum 31-night stay. There were no documented complaints on this property, and no other actions were taken.
Any other questions for Mac? Okay, if you would, state your name and address and tell us why you're here.
My name is Cody Wilkins. This is my wife, Angie Lawless. We live at 2216 11th Avenue South. We are here to appeal the denial of our short-term rental permits for our 2 rental units at 803 Hillview Heights. We have operated short-term rentals since 2016. We have 4 permits, including these 2, one for our primary residence, which we have a owner-occupied permit for, one for my prior residence, which we have a non-owner-occupied permit for, and then these 2, which both have multifamily permits. We bought these in 2016. First, let me back up. We've on all 4 of those, we've gone through the appropriate permitting process prior to initiating any short-term rental activities. We purchased these units in question in June of 2016 with the intention of establishing them as short-term rentals and obtained short-term rental permits at that time. The seller from whom we purchased them had also operated these as short-term rental units, and we bought them with the full intent of using them as short-term rentals. To our knowledge, all the units within the condo complex are short-term rental units at this point in time, and it was marketed and sold as such. When this property was redeveloped, it was built in 1960 and then redeveloped in 2014. And from my understanding, all the owners in there bought their units to short-term rent them.
So you forgot to
We forgot to
renew your
renew, yes, sir.
Yeah, so actually, sorry, I'm Angie Lawless. So what happened was I was trying to get everything like on my calendar and Outlook so that I could renew them because I was afraid with all the dates going around that I was going to miss that. And so I was emailing with, can't remember, but somebody in that department to get them. And I was like, hey, like, I was actually emailing on his because his is one of the ones that was grandfathered in that I knew I was afraid if it didn't, it wouldn't get renewed because of the recent law changes. So anyway, and so I had said, and that time I was like, oh, and hey, by the way, like, do I need them on, like, with all the recent law changes, do I still need them on these? And which I realize now sounds a bit idiotic, but with all the recent changes and everything, because this is like, because everyone in there is, I think I was mainly saying, I don't recall getting one of those. I'm not sure, like, if I have, do we still have to have those? And the guy was like, hey, yeah, by the way, like, you're out of compliance. And so at that point is when we realized, and I think, for us, like, our only real appeal is yes, like we did get one before. It looks like that there had been a period of time since, like, absent-minded life, whatever you call it, 4 kids, I'm not sure. But, we have continued to pay taxes on them to the extent that matters. We have, like, immediately when we found out, we, did not rent any further under short-term rental.
So what about it says 7 documented stays in March and 3 in April. Why would that be?
Well, we did continue to let the ones that had booked, we did not cancel those because to us, we thought, moving it to long-term rental for a period of time, it would still be bad to, like, just cancel on those people so close in time. So, but we did not book any further.
And just so you guys know, we found out on, I think, 2/26, and I was in here on 3/8 to try to get my permit, and that's when we found out that the lapse had occurred. And on the other ones, we mailed them back, and we always have mailed them back. And, anytime we've gotten those in the mail, sending the $50 check and signing the affidavit's never been a problem. We just didn't think to, I guess it slipped our minds that those 2 didn't show up.
I realize this is not a defense, but they said that my office had changed from changed addresses, which is where I get all of my mail, and so I didn't get it for these 2, and I again understand at this point that is on us to know that, but it's a human defense if not a legal one, I guess.
Okay. Any questions? Any more? Mike, did you have anything else to?
Well, so people forget to renew the permit. I get that. What concerns me is that after you weren't permitted, it looks like there were maybe 10 more rentals.
Well, those were bookings prior to finding out, and we felt like it would ruin our ability to, if we canceled all of those reservations, it would have ruined our reputation and ratings to be able to book all of our properties.
Not just that, like, honestly, like, I just felt like terrible. It was almost like if I need to pay, a fine rather than like tell these people that, that there's stays that are coming up immediately. So we thought that we would just get here and see what needed to happen. And maybe that is like, error on our part. But truly, that is how I felt. I did not want to like just call those people and tell them that because I missed to pay a $50 fee, that I had to like ruin their vacation, given how booked up everything is in Nashville. I did call around to some of the other people who had units in there to see if they could accommodate a couple of the stays. And after that, I was like, they couldn't, and I didn't know what else to do on it. And I just, whatever comes our way with it, that was the decision that we made.
Any other questions? Do you all have anything else to add?
I don't think so.
Right. All right, we'll close the public hearing. Thoughts?
Well, I think that there have been, to my recollection, at least several of these cases in which people have, to comply, canceled bookings that they have, and they just kind of, and we've generally taken that into account, and I think, I understand their dilemma, and I understand it, but I think as a matter of being even-handed about this, we have to recognize that we've had lots of applicants come here and that have canceled bookings that were in place before they knew about their permit expiration. So I'm not sure what, you have Chairman, you have a longer history with kind of knowing how the board has handled these. I know that when you feel like that there's, been strict compliance after you realize after someone realizes that they're not in compliance, that you generally let them renew pretty quickly. I don't think I'm comfortable with that in this situation, but.
Well, I agree. I think there needs to be something because of that, and it was, I don't think it was an intentional, I think it was, we have had people that come here, like this applicant, that, that testify exactly the same thing, to say, how can you be the friendly city of Nashville and then turn people away when they do that? It felt like the neighborly thing to do, and it was testimony that was, to me, came across as made in good faith and goodwill, and I think that this is the case here too. But it is not the same category as someone who gets a letter from codes that says, hey, anything you do after today, we're basically going to take you to court. And that should be a pretty strong signal to say, all right, I got to stop. There also, to me, is a difference between expired permits and people who don't have a permit. And I find that folks that rent after they know they're supposed to have a permit and have never gone through the process, I do find that to be worse. And so to me, the board has often, but not always, on people who behave perfectly on an expired permit, say, go get your permit tomorrow because you've already gone through the process. And so to me, this is, I think because of the nature of what they said, I think it's kind of 2 months after the last rental is kind of what I'm thinking is middle of June, just only because it's an expired permit. If they never had a permit before, I would say it would be closer to, 6 because you ignored the rules. But because they've already been through the process, and it's not, it's like continuing to operate on an expired tag after you've been told you can't operate on an expired tag. You still had to me, I don't think it's as serious as the other,
and I'm happy to note that they haven't had any complaints, so they've had the kind of tenants that were mindful of their neighbors.
Well, and it's a building that's specific, it's a type 3, it's a building specifically designed for this, sold as this. So, to me, the specific site makes it a little bit unique. It's, but tell me what y'all are comfortable with, because we all have to agree, but I was, anything, so that was kind of my floor, was to say middle of June, 2 months after the last rental, which was apparently mid-April. But again, that's.
No, I think 2 months after the last rental is appropriate, and I would support that.
Okay, I'll move that the zoning administrator did not err, that the applicant did operate on an expired permit, and that the applicant would be eligible to apply for a permit 2 months after the last documented stay, which we believe to be April 15th. So they would be eligible to apply on June 15th, or the soonest business day after that.
And I'll second it.
All right, got a motion, a second? Any discussion? All in favor, say aye. Aye. All right, you're eligible to apply June 15th or the next business day. I don't have a calendar to know what day that is, but good luck. Thank you. Last case.
Last case for the board to consider is case 2019-209 involving property at 316 Wilburn Street. This is an item A appeal challenging the zoning administrator's denial of a permit due to operation without the legally required permit. Is there anyone here in opposition to this case? I don't think there's anyone else in the room. So seeing none, the appellant, after Mr. McBroom makes his presentation, Ms. Porter will have 5 minutes to make your desired presentation. Please do identify yourself by name and address whenever you speak to the board.
This property's first online activity occurred July the 14th of 2014. There were 26 documented stays in total, 11 in 2014, 8 2015, 3 in 2016, 1 in 2017, and 3 last year. Host letter was sent on December the 10th of 18, and estimated delivery would have been the 16th of December. Advertisement was removed on the 19th. On January the 2nd, Ms. Porter initiated an email correspondence with zoning examiner Robert Osborne, seeking instructions on obtaining a permit and also how to file an appeal before the board. On 3/19/19, the BZA appeal was filed. There are no documented complaints associated with this property, and no other actions were taken.
Any questions for Mike? Thank you. All right, tell us your name and address and why you're here.
Okay, so Alexandra Porter, 316 Wilburn Street. I'm just here to ask for permission, I guess.
Excuse me, ma'am, would you move that speaker closer to your mouth? I cannot hear you.
Sure. I'm asking for permission to apply for a permit before the one-year probation period is up. Sorry.
Move that toward.
Okay, this is better. So I'm just asking for the permission to apply for a permit before the one-year probation period is up.
You know what, you cut the microphone off next to you. I think that may help. There.
Okay, sorry. Yeah, so I just didn't realize, I guess, that there were like other things that I had to do with the city to be able to list my house on Airbnb. I've been doing it for a really long time, since 2014. It's kind of slowed down a little bit, but yeah, so I just kind of want to make sure.
Is this your personal home?
Yeah.
And so do you rent this, do you usually there when you rent the home, or?
No.
So it'd be when you're a weekend, you're gone?
Yes,
you'll rent the home?
traveling for work and things like that.
Okay. And is the documented stays close to the accuracy of the number of times you've rented the home?
I think so. The last rental I had was December of, the 29th of December of last year. I'm not sure if that was like part of the information.
In December after you take?
Yes. So I was out of the country when the letter came, and so the girl that was watching my house opened it for me, but she didn't say, like, she just said, I think they want you to enlist it. She didn't say anything about canceling reservations, so I still had that one, but I didn't have any after that, so that was the last time that it was rented.
All right, anything else to add or questions? Did you have anything to add to us?
I don't know, is there any other information that I should?
I'm sorry?
Is there anything else I should be, I don't know, sharing? Taxes have been paid. I took the listing down as soon as I realized that I needed to. So I'm sorry, I just didn't realize.
Okay. Great. Well, we will close the public hearing. So this is a case where the letter came mid-December. The applicant was out of town. They had one listing as soon as it was apparently after that, which was not documented, but it's something that the applicant had let us know today. And has not rented at all this year. This is, to me, even if we if you consider the one rental, even with the time, let's just assume she knew, although the testimony was she didn't. It's, to me, it's in that kind of that 3-month range that we do, and 3 months to me from the last rental, we're already, 4 months past that. So to me, I think the effective penalty has already been served. So unless others object, I would move that the zoning administrator didn't err and that the applicant be eligible to apply for a permit on Monday, based on the fact that a 3 to 4 month penalty might be warranted, and that time has already been served since the last rental. That's my motion. All right, okay. I was like, well, that didn't go anywhere. Somebody else is going to have to make a motion. All right, we have a motion that's been seconded. Any discussion on the motion? All in favor of the motion, say aye. That motion passes. You're eligible to apply for permit Monday. Don't rent or advertise until you get that permit.
All right, thank you very much. I appreciate it.
All right, we're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.